In a car accident case during pretrial testimony, if the defense attorney turns around and asks if you beat your spouse every night, do you have to answer that question? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So now you've brought a lawsuit seeking compensation for the harms and losses you suffered because of another driver's carelessness. And now during the course of litigation, you are now going to give testimony, pretrial testimony, in your attorney's office. And now the defense lawyer has an opportunity to ask you questions about what happened. So now if the defense attorney turns around and says, "How often do you beat your spouse?" Do you have to answer that question? In New York, there are only 2 instances where you do not have to answer a question by the defense attorney in your accident case. The first is when the attorney is asking for information about a conversation you had with your attorney. That's known as privileged and confidential material. The second is if the attorney asks for something that is totally and palpably improper. Now, asking you about whether or not you beat your spouse every night, is that related to the claims that you're bringing for someone else's carelessness causing you harm and injury? Or is it related to the defenses that they are raising? Does that have anything to do with your injuries, with the claims, or the defenses? The answer is no, it doesn't. So what does that mean? It means that you have every legal right not to answer that particular question. In that instance, that question is so outrageous, so off the wall, having nothing to do with anything in your particular case, that would be palpably improper. And it would be perfectly acceptable for you not to answer that specific question. It doesn't matter what objection the attorney makes. It doesn't matter what reasons he gives. If it has nothing to do with the claims you are making, if it has nothing to do with the injuries you're making, if it has nothing to do with the defenses in the case, then that would be palpably improper, and your attorney is going to raise a big objection saying, do not answer that question, it's palpably improper. So why do I share this quick information with you? I share it with you to give you an insight and an understanding into what goes on occasionally in an accident case here in the state of New York. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter did happen here in the state of New York and you're contemplating bringing a lawsuit for your injuries that you suffered because of another driver's carelessness, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.